Not every divorce ends the same way. Some couples reach an agreement and move on, others battle over every issue in court, and sometimes one spouse doesn't respond at all. Whether your case proceeds by default, settlement, or litigation can dramatically affect how long your divorce takes, how much it costs, and how much control you have over the outcome. Today, we're breaking down the differences. Hi, I'm Ben Vojtik. I'm a partner with the Hartley Law Group. I'm licensed to practice in Texas and California. Every divorce case has one common objective, and that is to reach a final judgment. The final judgment in a divorce case contains all of your final orders. That would include division of property, debt, parenting orders for child custody and visitation, child support, spousal support, and even attorney fees and costs, if all those are appropriate in your case. All of these provisions are in the final judgment, and they can be reached one of three ways: by default, by settlement between the parties, or through litigation. The ease and cost of reaching judgment, from easiest and cheapest to most difficult and expensive, is just that, in order: default, settlement, trial. You proceed in default when one party decides to not participate in the litigation by failing to respond. It's basically like showing up to a potluck when you don't bring anything. Everybody else decides what you get to eat. Ignoring a legal case is one of the worst things you can do for your rights. Essentially, it puts you in a position where you don't and can't oppose any of the other party's assertions. You file a request to enter default, you propose the judgment, and you have a prove-up hearing where the court can approve the unilaterally proposed judgment. Now, most cases ultimately settle. The way I approach settlement is by conducting an analysis of the facts and making sure that you know what your best case scenario is, what your worst case scenario is, and where the court will likely come down. Figure out what outcome for what issue is most important to you, and maybe compromise on some things that aren't as important. Settlement is often quicker than litigation because the courts move slowly. This also leaves the parties in control of the outcome of their case more so than litigation. It's also possible to settle on some issues and push other items to trial. You don't need to litigate the pots and pans just because you can't reach an agreement on support. The most expensive way to reach judgment is through litigation, taking the case all the way to trial. Now, more than 90% of family law cases settle, and they don't go that far. But every now and then, there's just no middle ground. Maybe there's an issue like a prenuptial or postnuptial agreement where it's winner take all, or the setting aside of a deed, separate or community property characterization of a business. Maybe the other party just isn't willing to be reasonable, and it's just going to be a better approach for them to litigate the matter. It's the job of your attorney to assist you not only with the approach to your entire case, but on each individual issue as to what approach you should be taking to your case. I'm Ben Vojtik, partner with the Hartley Law Group, and I hope this video has been helpful.